Thank you so much, Diệp. Thank you so much, AmCham and IPBA for the conference. And once again, please come to IPBA in Tokyo this April for Sakura, like Fred said. And before I start, I know I already have 15 minutes, but I would like to thank and commend Diệp for setting a very wise agenda. First, you have Just Food that's setting key issues like document, burden of proof, power of the court, general principle of Vietnam law. And then other speaker, they follow that suit and they say, okay, about that 4 issue, what about Singapore? What about Japan? What about Germany? I have to confess that my presentation is the most messy one because I don't follow that 5 issue. But in the course of presentation, I try to make it into the 5 issues, so that in the end we have 5 takeaway points. And just bear with us. So I present briefly the case study for the 2 topics. First is about the setting aside of the domestic award, Vietnam award, and the second is non-recognition of foreign arbitral award in Vietnam. By saying domestic award, I come back to just full question is what is foreign award? So ICC award in Vietnam is a domestic award, or is it a final award, a foreign award? That's something is still debatable. But just to highlight some interesting point, and I also have to thank Just Fu. He's the only judge that I know that so far that cite New York Convention, because all other Vietnamese judges just read Vietnamese law and that's it. And I think at his age, he's the only judge that speaks English, because I saw that he listened to Tezuka Sensei and La Sensei very excitedly without any translator, so he understands everything. I was amazed. So I go quickly for this is I think it's very similar to Japan and Germany and Singapore. Probably we also follow UNCITRAL model law. However, we don't use the word public policy. We use the words basic principle of Vietnam law. Is that important? But being benefit from hearing from Tezuka Sensei and La Sensei, I think the name is not that important, because in other countries they also mention about interest rates and public interest and a public policy, and they think about indisputed fact as public policy. So what is in Vietnam? What is basic principle of Vietnam law? That resolution 01 say that basic principle of Vietnamese law is the effective basic rules for formulation and implementation of Vietnam law. Still very vague, and so I think it's something that we have to be aware of. But there is something to note here is that the court is not allowed to rejudge the content of this dispute. So that means that is Vietnam is upholding the principle of res judicata. Now let's say whether in fact Vietnam is upholding the principle of res judicata. So let's say if there is a decision quite famous recently is on the setting aside, is that there's a dispute between a Singaporean company and Vietnam company on a guarantee of obligation in the share purchase agreement. What the court said that the foreign document received without consularization is contrary to the Civil Procedural Code. And you may say that, okay, what CPC had anything to do with arbitration? And I also feel puzzled about that. And they say that, okay, because CPC is also the law of Vietnam, and the general principle of Vietnam is in Article 4 of the Civil Code, say that you have to follow the law. And because the law on arbitration did not say anything about consularization, so in that case, the CPC will fill in the gap. And because so the CBC apply because the LCA, the law on commercial arbitration, is silent. And then the other party say, okay, how about I notarize it now, consularize it now? The court say, no, you cannot. So that is also contrary to the principle of the LCA that say that if you have a chance to correct the award, you can correct, or to supplement. They say, because when you send a letter to VIAC, you already have to consularize it. Now it's too late because the VIAC has already confirmed the jurisdiction. So they also say that if the judge denied an argument is deemed lacking objectivity, and there is a principle of commercial arbitration law, the LCA, that you have to remain impartial and objective. So if you are not objective and impartial, that's contrary to the general principle of law. I mean, Article 4 of LCA is the general principle of arbitration. But is that a general principle of Vietnam law? That's something we don't know. I mean, the judge can say that Vietnam law, LCA is also Vietnam law. So general principle of LCA is the general principle of Vietnam law. But whether that would be the case, that's very interesting. And even there is no general principle in Vietnam law saying that you have to follow the law. Because if you apply that principle, then any law would be a general principle, violating of principle of Vietnam law. So that had been set aside very recently in 2023 in Hanoi. And people talk a lot about this case. I just want to repeat this. And it's also, consularization is a really big burden. Then another decision is about, in 2023, is about the dispute over the damage for not paying the franchise fee during the COVID time. This one is also set aside in Ho Chi Minh City. Now, what happened in this case is that there is a restaurant during the COVID time, they don't pay the franchise fee. And then the awards say that, okay, COVID is not force majeure, therefore you still have to pay the franchise fee. The court say, no, COVID is force majeure. And in the franchise contract say that in the parties does not have to pay, they would be waived, or they would be suspended from obligation, or would be released from obligation if they are impacted by force majeure. And therefore, requesting the respondent to paying fee during the force majeure event is contrary to the franchise contract. And because the franchise contract says so, but you don't follow the franchise contract, you are violating the principle of freedom of contract. And the principle of freedom of contract is the basic foundation for the Vietnam legal system has been built. So therefore, it's contrary to general principle of Vietnam law. Now, I think in this case, the court in Ho Chi Minh City is very wisely using the word general principle of Vietnam law, because I have to say that their argument is still better than the court in Hanoi. Why? Because in Hanoi, they refer to CPC, which is totally different procedure, to the LCA, to the arbitration. Here, they refer to the substantive law. And I have to admit that I recognize that freedom of contract is a general principle of the law. Has to be. I mean, Vietnam law is the law built on that principle. But so if a judge, or if the tribunal make a decision is totally different from what the party has agreed on, based on an undisputed fact, then it's contrary to general principle of Vietnam law. But in this case, the fact is dispute. Whether COVID is force majeure, and because it is res judicata, whether the court have the right to rejudge whether a matter of fact, as a matter of fact, a force majeure is the is the force majeure. I mean, COVID is the force majeure or not. I think the court does not have the right to reconsider the fact, but they have the right to reconsider the application of the law. If the fact is undisputed and everybody say that COVID is force majeure, and then in the end, they still say that, but you still have to pay the franchise fee. And the contract clearly say that in the case of force majeure, you don't have to pay. Then it's contrary to the general principle of Vietnam law. And if the court does not recognize the freedom of contract, it's also, I think, is a violation of public law. So in this case, the case is set aside. In principle, I could agree, but I don't agree that they rejudge. I mean, they rejudge the matter of fact, which is disputed. And also, the judge also say that the quantum for the cost incurred or to be incurred is not clear to be confirmed as an actual damages. I would say that, okay, so what? Because that is also a matter that you cannot rejudge what the tribunal already decided. So in this case, the tribunal, they use an audited statement, and they say that because the number of the audited statement is is about the profit, so they lost of that kind of profit, so that should be the profit, the general revenue over the years like this. So is it the profit to be incurred? And they say that, okay, but that's last year. I'm not sure this year whether you can have this. So therefore, you make a decision not based on a reliable evidence. So that is, I think this one is wrong. This one is go a little bit too far for setting aside. And maybe later on, I would like to ask Just Fu for his comment, also Tezuka Sensei and La Sensei, for in what respect you can say that it's contrary to the principle of Vietnam law, and in what respect it cannot be. Then it's about the decision. I think also the two decisions in Ho Chi Minh City. But showing that, I have to say that in Hanoi is even more. But I just picked the case in Ho Chi Minh City as a case, and most of the cases happening in Hanoi or Ho Chi Minh City because most of the seat of arbitration is either Hanoi or Ho Chi Minh City. Sometimes we have a case in other provinces because the seat of the arbitration is elsewhere. Now, the decision is dispute over the building structure of supply construction contract between the claimant and the respondent for the arena project in Ho Chi Minh City. And in the award, there is the tribunal say that you have to release the warranty amount because you win. The contractor win, so the employer have to release the warranty amount. But the employer say, but that was not been asked in the petition. So in this case, the court have goes beyond the scope of jurisdiction. But I think in the presentation from Singapore, there was a case I heard. Please reconfirm that the court, the tribunal is allowed to give any award that is consistent and similar. I mean, to support the main award. So I would have to ask La Sensei and Tezuka Sensei later on that what would Germany or Japan would make decision in this case. But in this particular case, interestingly, the court say that, but because you don't follow the okay, they're very interesting they interpret the principle of freedom of contract. They say that the freedom of contract say that if the party choose the law of arbitration, then the law of arbitration becomes an agreement between the party. right? Because they refer to that into the arbitration court. And the law say that you have to follow the request of the petitioner, and you make a judgment, you make a word that not within the request of the petitioner, that you are not following what the parties agree. And that is a little bit complicated, right? But I think you still follow me. And that means that you violating the principle of freedom of contract, and therefore is violating the principle of general principle of Vietnam law. Yeah, and also the court also say that another one is that the tribunal did not collect and assess the evidence properly, and that is also they readjust the case. They say that okay, there is the disputed facts, and the claimant showed this evidence, the respondent showed that evidence. The tribunal accept this evidence, but did not consider the other evidence. And the judge say that the court say that if I were you, I could have reassessed that evidence to see that whether between the two evidence, which one is more reliable. So since you did not do that, you have, I don't know, I would ask, okay, so what? But I mean, since you did not do that, I set aside your award. And I think in this case, I think because the judge is biased by the way that they trial a case, and I would have to ask Judge Fu if that is true. In arbitration, the arbitrator only look at the specific questions of the claimant. At court, the court have to bring justice to the case, so they have to look around and find all the way and weigh all the evidence to get into the ultimate truth that who should win the case. And also not to say that the decision in Vietnam is the procedure in Vietnam is inquisitorial, same like in any civil law countries. So so they make the judge become curious and look more further. Also that is the decision 578. Another decision is what long time ago. So I think now the mentality has been changed in 2018 when the court, the parties agreed that the dispute will be settled by Ho Chi Minh City Economic Arbitration Center, and that center doesn't exist. And but the party did not attempt to agree to set up a new center. So therefore, I mean, set up to appoint a new center, and therefore the award was set aside. I don't know. I don't know a real fact about this, but in reality, the party may attempt to agree, and if they don't agree, then they can submit to whatever the claimant wants. And the respondent has object jurisdiction, but has not been considered by the tribunal. This is very interesting because the tribunal has an option either to make a separate award for jurisdiction or put everything together in single hearing and make a single award that deal with two cases. But they say that, oh, because there's objection of tribunal, the objection of jurisdiction, and therefore you have to consider that situation first. Now it's very interesting here. Case here is that how do we deal with that? Because under the LCA, the law on commercial arbitration, Article 43 or 44 says that before the court hear the merit, they have to decide on jurisdiction. So if you make a final award and say everything, that means that you have heard everything in relation to the merit, and then you make decision on the jurisdiction. Technically, what the court the tribunal could do is that, okay, I make the morning session on the jurisdiction, and at the end of the morning session, they have to announce that I think the tribunal has a jurisdiction. And then in the afternoon, we're talking about the merit. So everything has to be recorded. But this one is no clear instruction from either the court or the VAC that what the tribunal should do. Should they announce it verbally at the hearing, or they could say, okay, I heard enough, I have made a decision, but I don't announce. I will announce within 30 days within today that whether I have jurisdiction or not. Now let's take that part. I heard enough. I go to the second part. It's about the merit. Can they do that? So I think for the suggestion, I think it's that's for everyone to consider. So I would skip that. I think the audience would be more interested to see what about in non-recognition of foreign arbitral award. For the procedure for recognizing the foreign arbitral award, I think Just Wu already covered. So I would skip that. But one thing important that I think that would be the key difference between setting aside and non-recognition is that in setting aside, there is no judicial review. There's no appeal. There is no cassation. For non-recognition of foreign award, there is a judicial review. There is appeal. There could be a cassation. So since nobody guards the guard, then in the setting aside, there would be a risk. And I think I hope that what we can learn from the seminar here is that we should have the appeal or the judicial review so that to reduce the amount being set aside. Now, for the criteria for non-recognition, I counted that Tsuka Sensei have 9 grounds or 10 grounds. We have only 7 grounds, so we have less. So is that true? But let's see how does it work in practice. So there is a decision in 2019. So most good news is that most of the case that I cited was a long time ago. So recently there was less case that not being non-recognized. So that is a dispute over commercial dispute and settled by the Arbitration Center of Nut and Dried Fruit Trade Association in UK. So the court not recognize it because the arbitration agreements explicitly specify that the case should be resolved by CENTA, Arbitration Center Grain Association, not TNA. So, so the tribunal has made a decision outside its jurisdiction, and therefore is non-recognized. I don't have the access to the main case, but if that is the case, I think it's okay. I think if it's fair enough to not recognize this award. But there are, I think the people are already more interested in more setting aside, so not recognized, maybe less point to discuss, but there's main point to discuss is about, submitting evidence, the burden of proof that Just Wu said. So the commercial is a sales contract and settled by Arbitral Tribunal of Singapore International Arbitration Center. And the agreement was signed by an authorized person. So that is falling into the non-recognition criteria of capacity parties to conclude an agreement. And that is a very important part, is that normally when you do international arbitration, we make agreement and it's signed by the lawyers, counsel mostly. And the counsel at the beginning, they already have a POA, like they represent the client and all the matters in relation to this. But all the matters in relation to the dispute, does it include the arbitration agreement itself? So when they signed an agreement, like instead of 3 parties, 3 arbitrators, we now agree to have 1 arbitrator. They already amend the arbitration agreement, and they probably need a proper power attorney from the viewpoint of the court. Of course, we here to ask our expert from Germany and Japan that do they need an extra power attorney in this case? So this is signed by an unauthorized person. The documents provided by the executing party do not contain the evidence that the arbitrator has sent notice to executing party. That's exactly the point that Just Wu said. Who have to prove? and the executor, the one who the requester, they have to prove that, show me that I have you have sent the letters to the other party. Of course, the one who has to be enforced say that I never received that documents. Now, but I think the question of burden of proof here can be tricky, because if the judge asks the one who has to be enforced, they show me that you have not received that documents, he can simply say that I haven't received. What do I have to prove? I can only prove if I receive it, but I don't receive it. So I can just simply say I haven't received it. So the burden of proof, I mean, in the end, it doesn't matter who has to prove it. The one who the requester would ultimately have to prove that they have to send the other party or the tribunal already send a proper notice. So that falling in the non-recognition for adequate notification to the judgment, inability to exercise procedural rights due to valid reason. So I think here the other party have to show the other surrounding evidence that you did mention about that sometime in the party that you and I met, that you received that, then that is the proof. So I think that's most of the, another one is about the decision in 2017. And also there's many more that I can, I did not mention here for the Cotton Association. And that also surrounding the point that whether you receive, the party has been served a proper notice. So that brings the end to my presentation. And thank you so much for your attention.